as not indicated by your lordships on the last occasion,
Yes.
that the questions of law might be academic. There are certain individual problems and individual issues which have also been tagged. But my suggestion, subject to your lordship's approval and other side agreeing, for example, Mr. Diwan has some individual issue of one individual. But they can be taken care of on the administrative side with RBI, bank, Ministry of Finance, etc., for which we may not waste the time of the constitution. That can be one way of dealing. If everyone agrees, individual issues can be sorted out.
If, according to you, the constitution issues do not arise for consideration.
It is.
So we have, actually, we've circulated a compilation, whenever your lordships have had a chance to look at it, where we've placed before the court all the orders, the series of orders. I'm a little surprised that the expression used waste of constitutional bench's time, when a previous bench of this court has said that these cases must be placed before a constitution bench. So I'm going to read through the orders passed by constitution bench of this court, as well as smaller benches of this court, referring our matters to this constitution bench.
But
And I've placed all of that on record in
only a minute, Mr. Diwan. I didn't mean in a derogatory sense that wasting for 5 honorable judges' time is precious. That's what I said. I didn't say that we are wasting time. None of us are.
Your Lordship, maybe some of the petition, according to my Solicitor General, may be right or wrong, but not the all. So my request only one point, Your Lordship. Serial wise, Your Lordship may touch the petition which have the constitutional point, deal it. Which doesn't have the constitutional point, it should be discarded.
See, one
As
thing.
the Solicitor General want to say the same thing. If there is a constitutional point, it cannot be academic. It will affect my future, my country future for at large. So each and every petition should be taken up, whether the petition have constitutional point to be decided or not. If not, keep it one side. If yes, seal it. Your Lordship, either it is academic or not. That's what I meant.
See, normally what happens, may I say something? May I say something? Normally, when issues are raised before a constitution bench, I think it is the duty of the bench to answer them.
Yes.
But in the instant case, has it not become a fait accompli?
No,
So far as
Just-
the order is concerned.
I'm not for a petitioner who has an individual grievance. I'm only on the constitutionality of the actions taken for demonetization. And it has not become academic. With great respect, I've read your lordship's observations on the last occasion. It has not become academic. The issues are live. The issues may arise in the future also. Therefore, my lord, the issues have to be decided.
Answering for the posterity is one thing, but to say something for or against the impugned action at
Yes.
this stage, is it not already a
It is
fait
not
accompli?
academic. It is not academic. We will show to your lordships, it is not academic. For example, the 1978 demonetization was actually decided. Individual grievances, whatever your
Yes, there
lordship
can
say.
be.
I
There
don't
can
have an
be
individual.
diverse points of view, the academic or not. Of course, they are must be well received, I don't say so. But in my very humble understanding of the matter as it stands today, since the notification has now gone beyond and there is an ordinance and the act has replaced the whole thing, unless the act is challenged in a proper perspective with reference to context and what happens today, what grievance would survive today, if the act is not under challenge, where is the question of going back for notifications? And I think it's essentially academic, an academic declaration which may have a large number of political implications. So the court will probably defer to the need for not entering into the kind of academic declaration. In my petition, I have challenged act as well as notification itself also on the basis of constitutionality. I am confined to the Article 77(1) only, because now we are not following the constitution. This is a real fact. Everything going to be done by the cabinet without coming into the parliament. Every day tax is being imposed. Every day everything is going on. This is demonetization is also out of the same series. This is the first act
which was never placed
I
before
wish-
the parliament
I-
before declaring that it is going to be demonetization. Whatever you want to do within the constitution.
I only wish that the arguments
We
are
are
advanced.
within
One
the
minute,
constitution.
sir.
No, we are
Please,
within the
sir.
constitutional system. We are within the constitutional system. Now today this is a constitutional bench.
Suggestion.
Yes,
Because if it suits your, if it's appropriate, we have filed a compilation of which sets out at the beginning the orders passed by this court. I think if we go through the orders passed by the Constitution bench and other benches referring the matters, it may serve a purpose. May I request you to just, there are 4 or 5 orders which have been passed by this court, including those framing the questions. I think that will indicate as to how this case has developed and evolved, and then we can progress further as to how we want to proceed to the next step. May I place those judgments? And
As one, what we are suggesting.
Yes, yes.
There are totally how many? 40.
About 58.
There are 58 matters, right?
Yeah,
Now, we will take one by one first. Let us see.
yeah.
Supposing one for any reason has become infructuous, we need not keep. And only those, which are relevant, which are necessary, we will take up independently.
Very good.
Otherwise, there will be virtually, it is not possible to control also with so
You're
many
right.
petitions.
Very well. I might just indicate one factor.
Also be
Perhaps your lordships
Mr.
are aware of
Sharma?
it.
Your Lordship.
Your case we will take up at the end. निकाल के side में रख दो, हाँ? Last at the end.
I am saying something else.
Sorry. हो गया. Order is passed. At the end, you take this case at the end. At the end, remove that case. Which is your case?
162
What?
of 2020.
No. Item number?
Item number 728.
So 728. Keep it at side, at the end.
You see, I want.
No. You should not say anything unless we call upon you to say. No. At the end. हो गया.
Listen,
Over.
I want to say
Yes.
this argument, no argument. One line only. You will say no person should be allowed to repeat the previous argument.
All right. Now your case is at the end.
It should be.
We will fix a separate date for you.
No, Your Lord.
Yes.
Oblige.
I find,
Separate day, maybe. Separate day for you. Right.
I find the large number of
So
increase.
your lordships may just recall that in a previous order which was passed by this court, the Constitution bench has held that no other court should entertain petitions, etc. So that's one order which I wanted to draw attention to. And all applications and petitions should be filed in this court alone. That's one order. The other order is when separate writ petitions came to be filed because of this direction which was passed by this court. What your lordships thereafter ordered is that we are disposing of the writ petitions, but we are granting liberty to each of the writ petitioners to file an intervention application to assist the court and the Constitution bench. So those writ petitions were also closed, allowing us to approach this court because probably you didn't want a multitude of writ petitions to be filed, and that is the status. So we are entirely in the court's hands, but I thought it may be useful to go through these orders first, and thereafter, of course, as your lordship suggests, proceed sequentially or whatever manner the court considers appropriate. So I was just seeking permission of the court if you would allow me to place these orders as they evolve, so that we at least know the orders which have been passed by this court coming to this moment. That is my only request.
Mr. Shamdivan,
Yes.
we have also discussed
Very well.
just
Very
before
well.
coming, right?
Yes, yes.
Now, if the issue has really become academic,
Yes.
there is no point in wasting the time of 5 judges,
Yeah.
right? Now, we feel having regard to the passage of time,
Yeah.
if there is any individual grievance in any separate writ petition, we will tackle them.
Yes.
But otherwise, all these issues should we take it up at this stage.
It's not academic, Manoj. It won't be academic because as I'm now just on the last point which you correctly observed. If there are individual issues, the individual issues challenge will be at different levels.
Yes.
They will be at the challenge that, look, this particular statute is unconstitutional. Assuming it is constitutional, the action under the statutes is for whatever reason disproportionate, failing constitutional tests. So, as your lordship is aware, our challenges are layered. They are at different levels. So, there is an attack on the validity. Assuming the validity, as your lordships correctly hold, one thing I might just point out, I mean, it's just maybe of some interest because Mr. Chidambaram has already indicated that to the court.
Yes.
As far as the 77-78 demonetization is concerned, and we have placed that in the compilation, that decision eventually came in 1996 by a constitution bench, which examined threadbare the statute and thereafter went into the individual grievances and pronounced on the individual grievances by the constitution bench itself. So that judgment also we have placed in the compilation. So, I mean, not that that is binding on your lordships in the sense, but that's an indication as to how a previous constitution bench tackling an issue similar to this did proceed in the matter. They retained the matter and they eventually decided it. So, Manoj, I am only speaking now from the perspective of the individual whom I represent. We had filed a writ petition. This court said that please file an intervention in this lead case of Vivek Sharma. So that petition was disposed of. We availed that liberty and we have come here by way of an application, etc.
That, Mr. Shamdivan,
Yes.
with due respect,
Yes.
that was a time perhaps that order was necessary.
Yes, maybe.
Now everything is settled
Well,
down.
may I answer that?
Yeah, yes. Chidambaram.
1978 demonetization was by a separate legislation of parliament. Ordinance on
Use them. Yes.
The 1978 demonetization was by a separate law of parliament. Ordinance followed by an act. Now, earlier in 1948 or so, there was another demonetization by a separate act of parliament. Today, they have used the the Reserve Bank of India, sections 24 and 26. Now, whether a demonetization of this kind, we will show it is really not demonetization. It is new notes for old. It is really not demonetization in the sense that any currency is declared legal tender. Whether a demonetization of this kind requires a separate law, debated in Parliament, ordinance of course, but debated in Parliament, and then Parliament could have modified it. Can you invoke 24 and 26? That's not academic. That is a live issue. And tomorrow, if this goes unchallenged or unadjudicated, they can invoke 24 and 26 today. Again, whereas the two previous examples of demonetization were by separate act of parliament. And my submission will be this kind of demonetization requires a separate act of parliament, and 24 and 26 does not give you that power. 1. 2. 86.4% by value of the notes were withdrawn. The immiserization of the poor, I'm not raising all those. Those are in another forum. It can't be argued before court. Tomorrow, can you 24 and 26 be used to declare as illegal tender, no longer legal tender, 100% of the currency notes? 86 can become 96 tomorrow. 96 can become 98. Can you use that power? Therefore, please examine the power under 24 and 26. If your lordship uphold the power, that's a different matter. But please examine the power under 24 and 26. Please don't stop us at the threshold to say this has become academic. It will become academic every time because the demonetization is overnight. And they gave you a 2-day window to exchange, a 2-day window in some shops, pharmacies, hospitals, etc. After that, it will become academic always in that sense. But it's not academic. Your lordships, I would implore your lordships to please examine the scope of the power under 24 and 26, whether a demonetization of this kind, withdrawing 86.4% of all the currency notes in circulation, requires a separate law debated by Parliament.
But may I assist by
Right.
2 points I will raise.
Before.
First of all the other questions which are raised.
You say on the submissions made by
The distinction
Diwan and
between an
Chidambaram
executive
on this issue,
I would-
appears to be
I would like to
justified,
respond to
appears to be right.
I would like to slightly respond to that. But the distinction between an executive order or a statutory order under section 26 and a demonetization statute may be kept well drawn. But the question is today, what are we asking for a declaration? Declaration about that?
No, no, what
Does it meet constitutional requirements?
No, no,
Well,
Mr. Attorney, what is being sought to be argued is that whether such a demonetization can be done by exercising power under 24 or 26.
Yes.
Or whether it is necessary to have a separate statute for that. According to Mr. Chidambaram, the earlier demonetizations were by a separate act of the parliament.
if the court were to ultimately hold on addressing these issues,
Yes.
ultimately hold, yes, it requires an act of parliament. And what kind of declaration? That will be again a declaration sense. Instead of this, you could have done that.
No, but then.
That's the only.
No, but if you hold so,
Declaration is-
if you hold so,
is
at least in
required-
future, this can be prevented.
It looks very attractive for a future. But what I'm trying to say is, but even then, it will be certainly in the wisdom of the parliament, the act has now been enacted.
No, you may
The
not,
act, I'm sorry.
you may not be able to undo something what has happened.
That's right. That's a closed chapter.
For the future, whether this same kind of power should be exercised or not.
My only response is, would it be in the nature of an advisory jurisdiction by the court in future, you would do that?
The way it is said, not.
I only suppose it wouldn't, right? Your lordships may not enter into an advisory jurisdiction.
Strictly speaking, it may not be advisory.
In a manner of speaking, it would be an advisory.
Though we may not unsettle something, but we can always lay down a law.
Yes.
No, provided lords are striking down a law. If a law is being struck down, you lay down a law. But if your lords are not going into striking down the notification, the question of laying down a law may not ordinarily arise. Therefore, I feel
Many
it
of
would be
the-
a very
Many of the leading judgments of this court are advisory in nature, subsequent. For S.R. Bommai is
for a number of reasons. For a number of reasons.
The event had,
Lord, your lordship's,
I only
your
think
lordship's,
that
your
lordship
lordship's
treading on
power to give a declaratory order does not depend upon whether the matter can be, whether the relief prayed for can be granted immediately or you have to mold the relief. Your lordship's power under Article 32 and 226 and 142 is declaratory. You will declare the law. We need to know what the law is. Parliament needs to know what the law is. Government needs to know what the law is. When will this law be declared? If this case is not a suitable case to declare the law, the next demonetization also in the future, perhaps the same learned Attorney General will come and say, this has been done. So when will you declare the law? The declaratory power of this honorable court does not depend upon what relief you can grant and what relief you cannot grant. Kindly look at the language of 142.